Welcome to Protect Your Family's Inheritance in 20 or Less. This is a quick foray into the realm of more advanced estate planning. This is not about taking your estate and dumping it onto your kids and wishing them well. This is about seeing what more we can do for them. So, why would you want to protect an inheritance? First of all, there is the issue of perhaps you would have minor beneficiaries, somebody who's 18 or younger, or even just even a little bit older than that. There could be beneficiaries that are on means-tested government programs that could run into problems with an outright inheritance. There are beneficiaries that could develop addiction or psychiatric issues. There are beneficiaries with serious creditor issues, which could be problematic for an inheritance for sure. And then there are beneficiaries that may encounter issues in the future, and we'll talk about that more at the end. So, first of all, disclaimers. The information contained in this seminar is for Wisconsin estates only. Further, viewing this video does not establish a lawyer-client relationship between yourself and me, and this is an introductory video. Estate planning is very complex. If you want to do it right, you should talk to an experienced attorney one-on-one. So, key point right up front, real protection in an estate plan can only come with an expertly drafted will or trust. You are not going to get good protection for an inheritance if you rely primarily on beneficiary designations like transfer on deaths and payable on deaths. The amount of protection you can get in those instances are quite minimal, nothing what you can get through a well-drafted will or trust. So let's start off with minor beneficiaries. First key points would be that a person who is under 18 cannot legally inherit anything. The inheritance instead would be held by a custodian until that beneficiary reaches the age of 18. A custodian could be an individual or could be a corporation like a bank or a trust company. Now, but once that beneficiary reaches 18, watch out. What's going to happen when you have an 18-year-old with all of a sudden a big bag of money just falling into his or her lap? It's probably not going to be good news. So what can you do? The most basic option is by utilizing the Uniform Transfer to Minors Act, which essentially allows you to take the age in which the minor can obtain control over the inheritance and bump it up from 18 to 21. But that means at 21, they still gain full control over their inheritance. So a 21-year-old and a big bag of cash really is not much better in the eyes of many than an 18-year-old and a big bag of cash. They have not developed impulse control by then. They have not learned the value of a dollar. Lots of that inheritance is very likely going to be wasted, which is why I always prefer when you have or may have a young beneficiary would be utilizing establish a trust for the beneficiary in your plan. So you can put age restrictions on this trust. So you can say, well, not at 18, not at 21, but perhaps older will they gain control over their inheritance. It would always be used for their benefit, but until they reach the age that you decide would be best, a more mature person would be serving as trustee, who would be controlling the assets for the benefit of your underage beneficiary. So an example in my plans, not all the time, but most of the time what I utilize is the age of 25 to say if somebody's under 25, then somebody else will be holding the purse in an inheritance. Once they hit 25, they'll gain some or all of the control of the inheritance. There is no set rule on what the right age is. It all depends on the beneficiary and the amount of the inheritance. It could be 25, could be a little less, could be a lot more, but I use 25. Now let's talk about beneficiaries on means-tested government programs. So what do I mean by that? Some government programs, they are means-tested, which means that you cannot qualify if you have too many assets. They take a look at the means that you have the ability to pay for your own care, pay for your own services. And if you have too many, you're going to be bumped off that program. That can be problematic in some circumstances. The two major programs that I am often protecting for the beneficiaries would be SSI for disabled persons, and for Medicaid, which is generally we're looking at folks who are on long-term care. Now these programs, sometimes what you receive from programs, particularly in the area of SSI, it's very hard to replace with private dollars. To all of a sudden, well, you have the means of paying for your care now, but nonetheless, the program itself is invaluable to many of the folks who are on it. And very often, well, let's just say that the cap for these two programs can be as low as $2,000. It can be more, and you can own stuff like a house and a car, but as far as additional assets, it can be as low as $2,000. Folks in these programs can easily be booted off them through no fault of their own just by being the beneficiary of somebody else's estate plan. Folks think, well, they're doing something good by including somebody in their estate plan, but sometimes it can do more harm than good, and this would be one instance. So what can you do? The smartest thing to do would be to establish what's sometimes called a supplemental needs trust, other times it's called a special needs trust for the beneficiary in your plan. And the inheritance for the benefit of that individual goes into the trust. And then it would not be held against them when the program does a tally up of their available assets. They'll take a look at everything they have, but they will not consider what is held inside the supplemental needs trust or the special needs trust. The assets inside the trust can then be used to supplement the benefits that the individual is receiving from the program. So they can receive the help from the program and then receive a little bit additional help from their supplemental needs trust. And then when the beneficiary passes away, the assets would then transfer to your chosen contingent beneficiary, whether it be their children or whether it be another member of the family or to whomever you want to receive it. It would not be then subject to estate recovery, since it would be in a third-party special needs trust or supplemental needs trust. You would be able to decide who receives if there are any additional assets left. Beneficiaries with addiction or psychiatric issues. Folks tend to not want to speak about this issue very much because they think it's not happening in their family and that it would never happen in their family. But here's some key points. Addiction can happen to anyone at just about any point in life. And as far as psychiatric issues, some of these do not become prevalent or diagnosed until the individual is in their 20s or 30s. So if you have a grandchild who is still in their teens, they seem completely normal and fine, and you include them in your estate plan, something could happen down the line that would not be foreseen, like well, any number of psychiatric problems could just develop later on in life. So here's an example that is actually not too uncommon. An individual would be injured in an auto accident regardless of whose fault it is. The doctor prescribes a narcotic painkiller to help with the pain, and then the individual becomes hooked on it. They become dependent and eventually spirals into what I say a full-blown opiate addiction. This has happened to people that maybe not in your life, but you know about people who this has happened to. Some celebrities this has happened to. Jamie Lee Curtis, she talks about she had some pain issues after a surgery, and she became addicted to painkillers after that. She was able to kick it, but unfortunately some more recent examples like Prince and Tom Petty, they became addicted to painkillers and overdosed, and they did not recover from them, obviously. So it could happen to anybody. It doesn't matter where you grew up, what type of family you come from. These types of issues can just befall on anybody. So what can you do? You can include in your will or trust contingency language that would only be used if one of your beneficiaries, either a primary beneficiary or a contingent beneficiary who happens to be receiving from your plan, if they do develop such an issues. So example, so in my plans that I put together, whether it be a will or a trust, if a beneficiary is identified as having one of these issues, then the inheritance will be placed in a unique trust where the beneficiary would not have control over the assets. Somebody else would be serving as a trustee for so long as the issue persists. The beneficiary has no right to demand anything from the trust. It will all be within the trustee's sole discretion, and the assets will be used for the beneficiary's benefit for basic needs and for hopefully recovery if it's possible. And then if the recovery is achieved, it would be within the purview of the trustee to hand over controls when it's appropriate. Beneficiaries with serious creditor issues. Here's some key points to that. Whenever a beneficiary receives an inheritance outright, meaning it just comes in their name only, the inheritance is fair game to any creditors that the beneficiary may have. And sometimes, and this has happened, where beneficiaries that inherit whilst going through a bankruptcy proceeding, they never even see the inheritance. It goes right to the bankruptcy court. Persons with high-risk professions, doctors, lawyers, business owners, they're generally most at risk when it comes to creditors, when it comes to court actions. So what can you do for these types of instances? Rather than leaving an estate outright, you can do so in a special trust share that have what's known as spendthrift protections. So instead of going directly to the beneficiary, it goes to a share, it goes to a protected trust share. Assuming they're of age and assuming they have their act together, they can be their own trustees, so they have full control over the inheritance. But it would not be subject to creditor claims. A creditor could not force the individual to pay out from that trust. Now, so that's with creditors that you know of when it's inherited. But as you'll see, the issues that beneficiaries may encounter in the future. So what I'd be talking about? I'd be talking about things like divorce, lawsuits, bankruptcy, and creditors, as we spoke of. Well, up to half of all marriages end in divorce in this country. So when you receive an inheritance and you get divorced later on down the line, what you receive could be subject to the division and divorce proceedings, this being a marital property state. It's not necessarily going to be, but it's presumed that everything you own is marital property, and so it very well could be subject to a split in divorce proceedings. Personal injury lawsuits, you see the commercials from the PI attorneys who talk about the 6- and 7-figure settlements that they get for their clients. You could be on the wrong end of that, unfortunately. And many debt issues and personal bankruptcy filings stem from medical issues. I don't hear it. I won't listen to somebody say, well, I don't expect to have any debts. I don't expect my children to have any debts or any bankruptcy issues, because you never know. Something could happen in the realms of health that can cause serious debt issues and perhaps bankruptcy proceedings. So what can you do is, again, you utilize these spendthrift protections on the trust share, because whatever protection that is on that trust will stay with the inheritance. And it not only protects against creditors, it also protects against divorce, and it protects against lawsuits and bankruptcy proceedings. It can last for as long as there's something in the trust share. As long as there's an inheritance that has not been spent, that protection can stay with it, even if that outlasts your beneficiary's life. So if you leave an inheritance to a child with this protection on it, and they don't end up spending it all. They save it for a rainy day, they save it, that grows, they keep it as their nest egg, but then they pass away before spending it all. They could pass it on further on down the line to their children and would receive the exact same protection. So where can spendthrift protections really prove to be valuable? What type of assets are they most useful for? In my experience, it's for protecting land. Land is often the most personal asset that people care about, whether it be farms, family cabins, or hunting land, or the home that was built by your own hands 40 years ago. These are the assets that most folks seem to care about more than anything. They want this to stay in the family, whether it be the farm that had been in the family since the turn of last century, the family cabin that's been in the family for 3 generations, the hunting land that folks have enjoyed utilizing with their children and grandchildren, and they want it to remain in the family. If you leave your assets, your real estate assets, to your beneficiaries with this type of protection, there is a much greater chance of it sticking with the family in the future. I'll say, and rental properties was one last thing, a source of income that would be important to keep in the family. But this brings us to the conclusion. I will say one last thing about this type of protection, though, is that for the most part, these spendthrift protections are a once-in-a-generation chance. You cannot create spendthrift protections for yourself in Wisconsin using Wisconsin law. So if I wanted to create a trust saying, all right, I want to put my assets in there and have it be protected from divorce, creditors, lawsuits, and bankruptcy, I couldn't do it. I couldn't do that for any of my clients, but I can do it for the children. So you should be thinking really long and hard about what you can do for your children, knowing that it would probably be the only opportunity that they would have in their life to receive this type of guarded inheritance, which could be used for their good and for their children's good for the rest of their life, the rest of their children's lives. You can't do it for yourself, but you can finally start this for your family with your own estate plan. So if you want to know more about this issue or any other long-term care planning or special needs planning or estate planning issues, you can always visit my website at www.mcclearlaw.com. You can also contact me through my website, either by email through the website, or my phone number is out there. My office number is 920-221-0320. We can schedule a free initial appointment to talk about your estate plan. You can follow me on Facebook, facebook.com/McClearLaw, where I post regularly on these topics, and I will be recording more and posting more of these in 20 seminars. You could also search for my YouTube page. Go on YouTube and search for McClear Law Office. I don't have a fancy URL yet that's anything less than 50 characters. So you have to search for my office. This video will be up there along with dozens of other educational videos on the topics of elder law and estate planning. So thank you very much for watching.